feel like a strong. Yeah. What? Hello, everybody. We'll get started in about 1 minute.
Oh, there is one right behind you. Oh, perfect. Yeah. Okay.
All right, everybody, good afternoon. Welcome to the third session of ELI Summer School this year. This is the Clean Air Act. My name is Matthew Papier. I'm the Senior Manager of Educational Programs here at ELI. Each summer, ELI convenes a complimentary seminar series that offers an introduction to the legal and policy frameworks of environmental law in the United States. This year, we are alternating between having hybrid sessions in summer school and in-person sessions, and webinar only for sessions in summer school. You can see the full schedule on the PowerPoint slides that Sarah will share in a second here. But next week, we will be webinar only, then we're taking Independence Week off.
Doing this one. So as I was saying, we're taking Independence Day off after that, and then on July 9th, we'll be back with another hybrid version of summer school, which is taking place here in DC and online. So today we have an audience at ELI's office and on Zoom. We're so excited to see all of you here. All sessions of summer school will be recorded and posted to ELI's website within a few business days. They'll also be available on our YouTube page. So if you've missed any sessions, please do check them out online. So, yeah.
Okay, been told there's an echo. So you can find all individual sessions of summer school on our website at eli.org. You can also find all of the PowerPoint slides from today on our website as well, on each individual web page for summer school. So for the online folks, we'll post those in the chat. Now we'll go ahead and kick off today's session. We have a fantastic group of speakers here to teach you about the Clean Air Act. I want to take a moment to thank all of them for being here and for giving us a little bit of their time and energy. For our virtual audience, we have both the chat and the Q&A open. So throughout the program, if you have any questions, please post them in the Q&A and the ELI team will be monitoring them. You're also welcome to use the chat to interact with one another and just post any observations throughout the program. For our in-person audience, please hold your questions until the end, and we'll come around with a microphone for you all. I think that's pretty much all I had. So with that, let's begin. I'm now going to introduce our moderator, Jared Page. Jared's a staff attorney at the Environmental Law Institute. Jared works at the intersection of climate change, policy research, and education. He works on a broad portfolio of projects at ELI, including the Climate Judiciary Project. He has experience in both domestic and international environmental law and policy issues. Jared received his JD with honors from the George Washington University Law School. I'll hand things over to you, Jared. Thanks so much.
Thank you, Madison. Again, today, welcome to the 2024 edition of ELI Summer School. We'll cover the basics of the Clean Air Act today, and we've got 3 phenomenal teachers lined up here for you today, and I'll introduce them all in just a moment. But first, I just want to help set the stage a little bit and provide a little bit of context for their remarks. So I just want to sort of take a brief moment and mention some of the historic and political context that surrounded passage of the Clean Air Act and its development over the last several decades. So the Clean Air Act, when you hear the Clean Air Act, most people are referring to the 1970 federal law. There were laws on the books before that time, going back to 1955. But the 1970 law truly was a deliberate departure from earlier federal laws, and it sailed through Congress. So the initial bills passed 374 to 1 in the House of Representatives and 73 to 0 in the Senate before a House Senate Conference Committee produced the final version. What was in that initial law? The initial law focused on certain health-based standards, the National Ambient Air Quality Standards for criteria pollutants. And in the words of last year's moderator, Pam Giblin, it was elegantly drafted and came in at only 38 pages, that first law. So how did this law work? Well, it gave the newly created U.S. Environmental Protection Agency, the EPA, broad authority to define and enforce those national ambient air quality standards to be administered in cooperation with state, local, and tribal governments, this cooperative federalism framework that the law established and set out, that would become a cornerstone of future federal environmental laws as well. And over the next 54 years, there have only been a couple of major amendments. Congress amended the act in 1977 and again in 1990, each time ratifying or strengthening EPA's administrative decisions about what air pollutants were harmful to public health, what levels were acceptable, and how they should be regulated. So the 1977 amendments added pre-construction requirements, which the original act didn't have. The idea that you need a permit before you start construction. And it was based on Texas's program, which had started in 1971. And I just want to take a moment here. So there's some really interesting inside history related to the original bill and the crafting of some of these amendments. And if you're interested, I'd suggest checking out an interview between Scott Fulton, one of ELI's former presidents, and Leon Billings, who was a former staffer with the Maine Senator Edmund Muskie, who was on the Senate Environment and Public Works Committee during the time that these laws were getting passed. To find it, just Google Scott Fulton, Leon Billings interview, and it should come up. So I won't spoil it, but there's a great story about Texas, Maine, and a phone call that explains how we ended up with the 100-ton threshold for a major source. And in the 1990 amendments, so 1970, 1977, and 1990, the act really expanded. So from that initial 38-page act in 1970, the 1990 amendments came in at more than 900 pages. So that was mainly the result of the addition of Title V, the permitting title. So over time, there had been sort of a pretty complicated scheme for permitting, and this consolidated permitting for a single facility into one process. And so since 1990, there really haven't been major substantive updates to the law. Most developments have sort of been in the administrative and regulatory space. But that means like the Clean Air Act that we have today remains a broad statute. It covers all kinds of air pollution from local, near, short-term to global and long-term pollution. And so to help us understand these topics and some of other air topics better, I'd like to introduce our wonderful panel. These folks work in this area day in and day out and really have expertise in this issues. And so it's really a pleasure to be able to hear from them today. So first, we'll hear from Daniel Schramm, who'll provide some of the general architecture of the act, looking at major provisions, the actors, really sort of from a bird's eye view. Second, we'll turn to Kelly Crawford, who will go deeper into how this law actually gets implemented, looking at more of a state and local approach. And then third, David Doniger will look into a specific topic, climate change, and how the act has or hasn't been able to deal with this issue. And hold on to your questions. We will take all your questions at the end in a Q&A session. So without further ado, I just want to say a brief word about our speakers before handing it over to them. So first, Daniel Schramm really knows what it's like in terms of the rubber meeting the road on air policy. So Daniel is an attorney advisor and a team lead at the US EPA's Office of Air and Radiation Law. EPA's office here develops national programs, policies, and regulations for controlling air pollution and radiation exposure. Think of topics like acid rain, climate change, energy efficiency, indoor and outdoor air quality, and more. And before joining EPA, actually, Daniel was a law fellow here at ELI. So welcome back, Daniel. Up after Daniel will be Kelly Crawford, a native Washingtonian and an award-winning expert at the forefront of developing innovative strategies that promote pollution reduction to mitigate environmental impacts to vulnerable communities. She is a senior advisor for energy and environmental justice at the U.S. Department of Energy's Office of Energy Justice Policy and Analysis. She works with DOE to craft policies that prioritize environmental protection and facilitate equitable access to the benefits of clean energy. David Doniger. David started his career also at ELI, believe it or not, and has been at the forefront of the battle against air pollution and global climate change since he joined the Natural Resources NRDC in 1978. In 1984, he famously argued the Chevron versus NRDC case at the US Supreme Court, a case that announced the landmark Chevron doctrine. He helped formulate the Montreal Protocol, an international agreement designed to stop the depletion of the Earth's ozone layer. And in 1993, he left NRDC to serve on the White House Council on Environmental Quality before rejoining NRDC in 2001, where he's now a senior attorney and strategist on climate and energy. And with that, turn it over to you, Daniel.
All right. Thank you very much. Hopefully the audio is okay. Nice to see you all. So you're going to get the most boring part of the presentation from me. Because I'm going to give you just a walkthrough of the statute. Jared also already did some good table setting there. So I'll try to move somewhat quickly. This is going to be a whirlwind sort of half-hour presentation on, as he said, a law that now spans several hundred pages. So obviously I'm going to skip over some topics rather quickly, but hopefully we'll hit the big points. And also just a word about my office in OGC, general counsel within EPA. The Air and Radiation Law Office is about 50 attorneys. It's the largest law office in OGC because this is such a big and complicated statute. So there's a never-ending stream of work to be done. And as I'll get into a little bit later, part of the reason for that, I think, is just how cyclical Congress designed the act to be. It really functions as, I like to think of it almost like a grandfather clock. It's a lot of gears and a lot of clocks ticking, and that's how Congress built accountability into the statute. But it also means that the work for the lawyers at the agency is sort of nonstop in terms of dealing with deadline suit litigation and making sure these actions get addressed in a timely way. Before I go further, I'll just point out this is educational purpose only. I'm not here to speak on behalf of the agency or opine on anything going on before the agency. So please understand that. And if I do start opining, somebody should kick me under the table and I'll shut up. Yeah. That's right. So a quick outline of what I'll go through: goals of the act, legislative timeline, which I think Jared already spoke to. What is air pollution? Organizational structure of the act. There are two major sort of components that work side by side there: the cooperative federalism model, as well as the direct implementation model, permitting, and then enforcement, judicial review, and the role of the courts. And I do have a slide at the end on pollution trends that I think is pretty interesting. So what are the general goals of the act? Fundamentally, to protect human health and welfare from air pollution. I think there's sort of two important components of that: human health, on the one hand, disease, morbidity effects, mortality effects, the things that affect humans and our health, as well as welfare, which goes to the larger economic effects of air pollution or its ecological effects. Both are components of the act, particularly in the context of the air quality standards or the NACs. The act does this work through kind of two different methods of standard setting. One is the health or welfare or risk-based standard setting. Examples of that are the air quality standards themselves, which are set to protect human health and welfare. That's a very scientific analysis that looks at what an appropriate level of air pollution in the ambient air should be. Hazardous air pollutants under Section 112 of the Act, those are the acutely toxic air pollutants. Those also have a risk-based component, although they also have a technology standard that we'll get into. And then the other major way that we do this is through technology-based standards. So standards that say, what is the best technology that we can impose here to achieve emissions reductions, sort of irrespective of health or risk-based analysis. Key examples of that approach would be the new source performance standards under Section 111, best available control technology under the new source permitting program, and the mobile source standards under Title II of the Act. The purpose of the Act really, as Jared said, starting in 1970, Congress recognized that there needed to be a substantial role for federal oversight in the implementation of states' efforts to reduce air pollution. So the modern Clean Air Act really empowers the EPA as a federal agency to serve that oversight role in a number of ways, but at the same time preserves important flexibility and discretion in the local and state agencies to figure out how they're going to achieve the federal standards or the federal targets that EPA is sort of charged with setting. The Act also has a number of provisions just to improve the scientific understanding of air pollution, to conduct research and development activities, to provide grants and assistance to others. So I think that non-regulatory component of the Act is something important and something not to lose sight of as well. And particularly with the Inflation Reduction Act, really there is a lot of effort in that area, more in the realm of moving money and moving assistance out to get air pollution reduction done rather than through sort of the regulatory model. I won't spend a lot of time on this because Jared did a very nice job. The key amendments obviously were the 70 amendment, the 1970 Clean Air Act, which is technically an amendment to the prior Clean Air Act, but that's the one we think of as the basic structure of the Clean Air Act. The 77 amendments, the 1990 amendments, among other things. I think Jared talked about a couple of these, but a huge expansion of the Section 112 program for hazardous air pollutants after there was sort of an inability to make much progress on that. Through the 1980s, Congress sort of stepped in and really juiced that program up. Expanded non-attainment planning requirements, particularly for ozone. Again, ozone or smog as it's called, was a sort of persistent problem in the 1980s. So there was an expansion of non-attainment planning requirements to get the country into attainment with the ozone standards and other NACs. The acid rain program under Title IV, which was a cap and trade program. And I think one of the other themes in the 90 amendments was the recognition that market-based programs could be effective for reducing air pollution. So in other ways, in the 1990 amendments, Congress authorized or encouraged the use of market-based programs. The operating permits under Title V, we'll talk more about that later. And then stratospheric ozone under Title VI. A note there, the AIM Act of 2020 deals with sort of a subset of that issue, addressing the ozone layer, and that's particularly related to HFCs or hydrofluorocarbons, which are highly potent greenhouse gases. 2005 and 2007, the addition of the renewable fuel standard, I think, is another important marker in the timeline of the Clean Air Act, and that has become an increasingly large part of our workload. We have a team of attorneys working on that. That's to incentivize the use of biofuels in the nation's fuel supply, particularly ethanol, which has become kind of a significant issue. And then 2022, we have the Inflation Reduction Act with the greenhouse gas reduction incentive programs that I mentioned before. So what is air pollution? A very broad definition of air pollutant in the Act under 302G. It can be almost anything, any chemical or substance that poses an endangerment. EPA does need to make that endangerment finding to then trigger other regulatory authorities or steps that can be taken to control that air pollutant. So so far, we haven't made an endangerment finding for frisbees, but greenhouse gases got that critical endangerment finding a few years ago. And so again, an indication of just the breadth of what Congress intended to be sort of covered by the definition of air pollutant. Then there are the criteria air pollutants. the ones that Congress was first concerned about in the 1970 amendments, the air pollutants that are kind of widespread and emitted from lots of different sources. And so for which we need air quality standards and then a method of implementing those standards. I also include their precursors here, not all of so the NACs are things like particulate matter or soot, ozone or smog, sulfur dioxide, nitrogen oxide, lead and carbon monoxide. I think of the 6 kind of NACs pollutants. Some of those aren't emitted directly, they have precursors. Ozone, for example, comes from NOx emissions and from VOC emissions combining in the atmosphere in a photochemical reaction. So to get to the ozone standard, we actually have to focus on regulating those VOC and NOx precursor emissions. Hazardous air pollutants, again, acutely toxic, carcinogenous, that sort of thing, under 112, the stratospheric pollutants, CFCs, HFCs under Title VI, and then other pollutants, this catch-all category into which greenhouse gases has fallen, and there could be others. Organizational structure, okay, part 1, the cooperative federalism model, and the NACs implementation process is sort of the key example of this, but there are other parts of the Act that work in a similar way. The NACs are set by EPA at a level requisite to protect human health and public welfare. And then the implementation is turned, well, I should say, I don't have a slide here. Then the next step is that EPA, in consultation with the states, designates areas of the country as either non-attainment, attainment, or unclassifiable. So that's an important step in that process. Where are the areas of the country that are not attaining the NACs? After that's done, we go into NACs implementation. That's where the action shifts to the states. They have to develop the state plans that will bring their areas into attainment of the NACs. And there are certain requirements that all states need to implement regardless of whether they have non-attainment areas or not. Those are called infrastructure SIP requirements. We'll get into them here. One of those is what we call the good neighbor provision, which is actually the area that I focus on, which addresses interstate pollution. So states develop their plans, or they choose not to. They could choose that. Those plans go to the agency, and EPA is either going to approve those plans or disapprove those plans. Or if a state doesn't submit a plan, then we make what's called a finding of failure to submit. If we approve the plan as meeting all the requirements of the Act, then the requirements of the SIP become enforceable federal law under sections 113, which provides for state and federal enforcement, and then also under section 304, which provides for citizen enforcement of the requirements of the Act. If EPA disapproves a SIP, then we must promulgate a FIP, a federal implementation plan, and that's under 110C of the Act. So if a state chooses not to or doesn't have an adequate plan, EPA steps in and plays that direct implementation role through a FIP. A similar cooperative federalism framework applies for the regional HAZE program. That program deals with improving visibility in Class 1 areas. Class 1 areas are national parks and wilderness areas. That was something added in the 1977 amendments. That's actually a fairly active area of Clean Air Act practice right now because we are in sort of an iterative planning phase process to restore natural visibility conditions in Class 1 areas. Permitting programs also submitted to EPA for approval. And then section 111D, David might speak more about that, but the program under 111 for EPA and states to develop emission standards for existing sources for pollutants such as greenhouse gases. A note on the tribal role: tribes can take over implementation of the Clean Air Act as appropriate if they are interested in doing that. They obtain something called treatment of state or task status. This is under 301D of the Act. Or EPA can directly regulate in areas of tribal jurisdiction if it's appropriate or necessary. So the other big model that sort of coexists with cooperative federalism is the direct implementation model. Congress in a number of places in the Act thought it was appropriate for EPA just to directly set standards or requirements without sort of working through the states. Again, the key examples here are going to be the new source performance standards for new and modified sources. That's under 111B as in boy, not D. D is the cooperative federalism model for existing sources, but for new sources, EPA just sets those standards directly. Solid waste combustion under 129 is sort of an adjunct provision that's similar in structure. The key standard here, best system of emissions reduction or BSER, considering cost or other factors. NACs and non-HAP pollutants are regulated under 111. 111D excludes HAPs and it excludes NACs. So it's just that other pollutant category, again, GHGs. Air toxics or NESHAPs under section 112. The standard there is maximum achievable control technology, or MACT. Not surprising, because these are the most acutely toxic pollutants. So Congress set a very high standard there, along with the residual risk review. 112 standards cover new and existing sources and major sources, which are above 10 tons per year, 25 tons per year, or area sources, which are the smaller sources of HAP pollutions. Mobile source standards under Title II. Again, EPA directly sets the standards for automobiles, airplanes, locomotives, ships, etc. Title II has a preemption provision, so states are actually prohibited from setting those different standards for engines and vehicles, which is not to say that states can't regulate mobile source emissions in other ways. They just can't regulate the engines. Okay. There's a special provision that you may hear about sometimes called the California waiver. There's a provision under the act that allows any state that had their own mobile source standards in place as of, I think, 1965, but don't quote me on that, but to actually continue to set mobile source standards. California was the only state in that position, so California is authorized to set their own emission standards. Other states can adopt California standards if they want to. Title II also sets direct standards for fuel additives, and the renewable fuel program, and the stratospheric ozone, Title VI, which I'm going to breeze over because I really don't know anything about Title VI. So the permitting programs. Okay, two basic types of permits under the Act for state. These are both for stationary sources. You've got the construction permits, or what's called new source review, NSR, also called Title I permits. They arise under Title I Part D. And there are two different types of NSR permits. Non-attainment NSR, where the statutory standard is the lowest achievable. Non-attainment NSR applies in areas of the country that are designated non-attainment. So you've got bad air quality. So before a new source can construct and emit more pollution into that area, Congress expected there to be a very rigorous new source review process to make sure that those emissions were kept as low as possible. Lowest achievable emissions rate is the statutory standard, along with offsets. So there's no net increase in pollution in that area. If you're in an attainment area, then a different set of new source review requirements applies, called prevention of significant deterioration, or PSD. And the statutory standard for that is BACT, or best available control technology. Permits must address all pollutants under the Act, not just the one that's relevant to the NACs in question. So it's a pretty broad analysis of what the control technology should be for those sources. And then Title V are the operating permits. Again, added in the 1990 Clean Air Act amendments. These permits serve a different purpose. The Clean Air Act is very complicated, and there's a lot of different requirements, many of which might all apply to a different source for different pollutants for different reasons. So in order to increase transparency, accountability, enforceability, and compliance assurance, Congress created the Title V operating permit program in the 1990 Clean Air Act amendments. So it combines or compiles all of those requirements into a single permit for each facility. Title V also includes a unique petitioning process where interested members of the public or citizens groups who believe a permit was issued improperly or contains flaws or errors, they can file petitions for the EPA with those objections, and EPA has to review those petitions and make a decision whether the permit was properly issued or not. And if not, then an additional process is triggered from there. Again, states generally run these programs. They design these permitting programs in compliance with requirements of the Act and EPA regulations. They submit them to EPA for approval. Most states have done this. Most, if not all, I can't think of a state that doesn't have its own permitting program. Generally, states run these programs after EPA has approved them. Then enforcement, judicial review, and role of courts. I started this slide, it's a little out of order, but I think it's important again to remember the way that Congress designed the Act was to make almost every duty in the Act subject to a deadline. And that provides for practical enforceability, because then if the agency or the state or others miss those deadlines, members of the public or organizations or other interested parties can go to court under 304 and file citizen suits to enforce mandatory duties. So I'll say a big part of our practice at EPA and General Counsel is dealing with deadline suits, because there's so many duties under the act that it really is very difficult for the agency to meet all of them. And then when the suits come, we will typically, we'll either litigate liability if we think we have a basis to, otherwise we're likely going to seek to settle that litigation and just arrive at a date that we can agree to with the plaintiff, by which we will take that action. In terms of more traditional enforcement, again, Section 113 is the major provision there, provides for state and federal enforcement of the requirements of the act. And the public can also enforce requirements that fall on the sources themselves, not just against EPA, but against the regulated entities for violations of the act as well under 304. When the EPA takes an action under the act, if we issue regulations, or if we act to approve a SIF or to disapprove a SIF, those actions can be judicially reviewed. 307B provides the general requirements applicable to judicial review. The couple of points of interest here, just these cases, they're called petition for review cases. They go directly to the appellate courts, the federal appellate courts. They do not go through the district courts. And then within that scheme, there is a division between those cases that need to be heard by the DC Circuit Court of Appeals in DC, and those cases that need to be heard by the appropriate circuit court, which is typically the regional court that has jurisdiction over the state or the locality where the action was applicable. This is a area of litigation interest right now, so I won't say more about that. But an interesting topic. And then finally, rulemaking procedures and legal standards for review. 307D is kind of a mini APA within the Clean Air Act. It sets for specified actions. There are some fairly prescriptive rulemaking requirements that are applicable to EPA that we have to follow. And in exchange, there are some procedural protections that the agency gains as well. And then that section also provides for the standard for judicial review, which is generally the APA standard, arbitrary and capricious review, which is very similar. Again, with some additional procedural protections for the agency. 307D also provides for a mandatory reconsideration process in the event that somebody can show that there was a EPA issued a final rule without sort of giving adequate notice of the requirements of that rule. So another area of practice in my office is oftentimes dealing with both the review of the rules as well as associated petitions for reconsideration, which often come in once we've taken our rulemaking action. So my last slide, and I hope I'm still within 30 minutes.
Very good.
Okay, great. Air pollution trends in the US. There are a number of kind of graphs like this. You may have seen them before. This is one that I got from one of our modelers in the Office of Research and Development. So I think this graph shows a couple of points that are complementary. One is obviously the act has been very successful in reducing overall air pollution, particularly of those criteria air pollutants. But certainly with NOx and SO2, which are precursors for PM and for ozone, PM levels themselves have come down, and that's a great success story, right? I mean, a lot of the complaints about the Clean Air Act have always been that it was setting really impossible expectations for what we could achieve and still have a growing economy. And there's just been a robust amount of analysis and literature out there that really shows that that's just not the case, that we have been able to successfully reduce our air pollution while continuing to grow the economy. And this is just one representation of that. But that's not to say, I think the other part of this graph is, that this is, we still have work to do. We still have non-attainment problems in this country. We have environmental justice issues in this country. We have greenhouse gas emissions as another. So the work of the agency certainly, the agency has its work cut out for it as we go into the future. So that's the end of my presentation.
Thank you so much, Daniel, for that great overview of sort of a bird's eye perspective and a national perspective of what's going on. And we'll turn now to Kelly, who will look at a little bit more of when the rubber meets the road and the implementation part of the act. Kelly?
All right, so I'm gonna try to keep it light and keep it simple. These are just some things I've heard from other air directors, especially recently. I'm a former air director myself. I used to be a state air pollution control officer for the District of Columbia. And so I'm gonna kind of go over a few things, just some key provisions of the Clean Air Act that states and local agencies implement. I'll talk about some of the different configurations of how these delegations are promulgated throughout the United States. I'll talk about key state and local activities, and then I'm gonna talk a little bit about partnership and collaborations, which is kind of a way that a lot of some of these Clean Air Act requirements come out. And I'll go over just some challenges that state and locals have. And so I love this quote here: "One must divide one's time between politics and equations." This is the life of an air director at the interface between the policy and the science, and carrying out the Clean Air Act statute. Air directors have the state air pollution control officers, which are often referred to as air directors. They have state air directors, the SAD people, and then you also have local air directors. I used to be a SAD person myself. SAD people are responsible for protecting air quality through regulation of emissions from industrial and local sources. They're also responsible for monitoring and reporting the ambient levels of air pollutants and providing state ambient air quality information to the general public. They have the overall responsibility for policy development, administration, fiscal management, and also working with local stakeholders. They coordinate with state, federal, and regional agencies to explore new legislative or interagency approaches to improving air quality, and also develop, implement, and enforce regulations required to achieve adopted air quality standards and reduce public exposure to toxic air contaminants. Depending on the state or the local locality, there might be any number of agencies that are part of the air quality management network. So I think there are 35 air districts in California, in addition to the California Air Researches Board. So they have a three-tiered approach. States like the District of Columbia has a single tier. I served as both the state and local air quality authority for the District of Columbia. But then you have other places like Maryland, where there is a state air quality program, and then there are local programs that are administered by like a local health department. So for example, Allegheny County Health Department is a local air authority that's administered out of a health department. And so like I was saying, the example I would just give is CARB, and they focus on California's unique air quality challenges by setting the state's own stricter emission standards for a range of statewide pollution sources, including vehicles, fuels, and consumer products. CARB is unique in that they do set vehicle standards. They have capability to measure, to verify automakers' emissions compliance with CARB's. They have their Dr. Mary Nichols laboratory in Riverside. And like they were saying, several states under Section 177 of the Clean Air Act can adopt California standards for vehicle emissions. And so over on the East Coast, if you purchase a vehicle in Maryland, you're likely to get a 177 compliant vehicle because Maryland is a 177 state. You would be able to register that vehicle in the District of Columbia, but vehicles that are non-California models won't pass the emissions inspections in 177 states. So that's just one way that states can adopt California's vehicle emission standards to address air quality emissions concerns in their locality. Good example of this is DC. I think over 70% of our locally grown emissions come from local sources. And so, especially in the ozone transport region, many of the air agencies have adopted those standards. Another very visible way that air agencies carry out Clean Air Act is through their monitoring programs. This is from Air Now. And has anyone seen this before? Air Now, do you know where this data comes from? It comes from your state and local air quality agencies who manage and operate this network. We talked a little bit about non-attainment areas. So non-attainment areas are, you didn't talk about, okay, design values.
No,
All right.
you're not getting design values.
I'm trying not to go like super deep nerd on you, but So non-attainment areas are classified on the basis of a design value. It's the fourth highest hourly reading measured during the most 3-year recent period. So over the last 3 years, the fourth highest concentration of a pollutant as measured by air quality monitoring devices. Is complicated. But essentially, like next year, we'll tell you if we had attained it last year. Or if we attained the national ambient air quality standards. So AirNow is a publicly available system that has an algorithm that translate all of this air quality monitoring data collected across the country from all of these different monitoring networks, and reduces it to a simple coloring system to help the public understand their air quality risk based on a variety of factors. This is for today. It's code yellow day, it's moderate. The pollutant that's driving this right now is, surprise, surprise, particulate matter. I was like hoping it would be ozone. We're dead slack in the middle of ozone season. And normally ozone is one of the highest drivers of poor air pollution in the summertime. We have the perfect storm of conditions to create ozone. But today, of course, to make my talk complicated, is particulate matter. We're also coming up to the 4th of July, which is an air quality holiday for my people. And then AirNow is it's a partnership. So it's a partnership between EPA, the National NOAA, National Oceanic and Atmospheric Administration, the National Park Service, NASA, CDC, but also tribal, state, and local air agencies. And that's a centralized data system to provide quality control and national reporting consistency. Air agencies got a lot going on. And so state and local air agencies are responsible for a whole host of activities. Most importantly is the state implementation plan. So this is our air quality planning. SIPs are based on emissions inventories, which we create the inventories based on computer models and this air quality monitoring data. Also, we use these models to show whether or not the state is going to meet the national ambient air quality standards. And if not, we propose new and modified sources that obtain like construction permits and other control programs to ensure that the attainment area does what it can to reduce emissions to comply with the national ambient air quality standards. The 1990 amendments required EPA to put sanctions on areas which fail to submit the state implementation plans or fail to complete adequate SIP. I think I'll skip this. Could you talk a little bit about SIPs? But just give some examples of the types of requirements for ozone non-attainment SIPs. Depending on the level of non-attainment, and that goes from marginal non-attainment all the way up to extreme non-attainment. But within that, there's various requirements that states will have to implement in order to show that they can come into compliance with the national ambient air quality standards. So for ozone, that might look like things like inventory emissions, offsets, minimum fines for violators, VOC emissions reductions, enhanced monitoring programs, adoption of enhanced vehicle inspection and maintenance programs, requirements for fleets to use clean alternative fuels, adoption of transportation control measures, and also, sorry, that's the last one, adoption of transportation control measures. So there's a whole host of tools in the toolbox, and the state has to come up with a plan, submit it to EPA, and if EPA approves it, it becomes federally enforceable. Any questions here? So welcome, friends. So there's lots of collaboration and partnership. Meeting clean air standards is not easy. It's actually very complicated. The atmosphere is chaos, and air pollution knows no political or physical boundaries. And so the problem of transported air pollutants is a particular focus as states and EPA attempt to develop compliance strategies to achieve both the ozone and the particulate matter national ambient air quality standards. There is a process, the 126 petition process, where states or downwind states can petition EPA to request that major and stationary sources located in other jurisdictions or another state that has emitted pollutants that is significantly contributing to the non-attainment of the national ambient air national ambient air quality standards in a downwind state. So there's transport regions that are also created in the Clean Air Act because there are certain areas of the country where it was noted that there is significant transport, especially of ozone. So one of those is ozone transport region. This is from provision 184 of the Act, and it required specific additional controls for all of the areas, not only the non-attainment areas, but all of the areas within that ozone transport region, which goes from Virginia up through now just the bottom part of Maine.
Oh, you know about the.
Yes.
You really keep up, yeah. We shrunk.
We shrunk the ozone. Go ahead.
Maine wanted to not be the whole state covered by the ozone transport region, so they filed a petition recently, which EPA approved, which limited the ozone transport region to just like the Portland area of Maine.
Yeah.
But they wanted to keep their foot in the door, so.
Yes. And so the Ozone Transport Commission was created by Section 184 of the Act for the purpose of recommending to EPA region-wide controls affecting all areas of the region. And that OTC is a multi-state organization created under the Act that's responsible for carrying out or ensuring regional collaboration. So OTC does things like develop model rules. Those model rules then in turn have to be adopted and incorporated to the individual state implementation plans of all of the member states. But it's a very much collaborative process. Also bundled with that, is how we address regional haze, very much in the same way. Multi-state, multi-jurisdictional bodies that come together to adopt model rules. In terms of roles, so the federal government is, so many of the provisions are carried out at the state and local level, and the federal government serves as a backstop. So they review the work of state and local actions and approve things like state implementation plans. They administer some permits, but review most, and if not all, Title V permits. And I think we've said it before, in the spirit of cooperative federalism, if a state or local authority is not, for whatever reason, able to make progress on cases or demonstrate progress in achieving national ambient air quality standards, then EPA can step in and be big brother and require affected states to revise their SIP or to ensure they include sufficient measures to bring that state to compliance, and that's called SIP call. And so since at the time the Clean Air Act was adopted, they were using 1988 design values, and at its inception there were 42 marginal non-attainment areas, 32 moderate, so really heavy, like higher numbers of areas that were non-attainment. So it was 42 in marginal, 32 moderate, 14 serious, 9 severe, and just 1 extreme. As of July 2022, we're down to just 38 marginal areas, only 1 moderate area, 5 serious, 3 severe, and 2 extreme. And so we've seen significant reduction in just the number of areas that are significantly or severely impaired for in particular ozone.
Oh, almost all of those marginal areas got bumped up to moderate in 2023.
Surprise, surprise.
But yeah, not to dispute the overall point.
Surprise, surprise. I have been at the Department of Energy for the last couple of years. I'm not surprised to hear that though. And so just to kind of run through some of the challenges that air agencies faced. One, the top is just attracting and retaining talent. One of my favorite things about air quality is everyone is such a deep technical expert, and people don't leave air quality. Like I left, but I didn't leave. No one leaves. And so many of the air directors and their staffs were around in the 1990s when these amendments were first put into place. And so as they began to retire or move on, there's attrition of institutional knowledge and looking for, and so state and local agencies face that in trying to maintain like inspection and enforcement staff. And then there's also, a lot of retirements amongst the air directors. And so if you think about There's about 140 state and local air programs across the country, but those are the only ones. So if you're looking for an experienced air director, you're poaching from another state. Funding constraints, much of the budget, much of the 105 and 103 grant programs that sustain the majority of the work under at the state and local level to conduct monitoring and inspections, not Title V, but other activities have remained relatively flat. Historically, there have been some special funds like IRA bill funding that have given temporary increases, but that base funding has remained relatively flat. And as things like costs for monitoring equipment and staff continue to rise, it puts constraints on state and local agencies to carry out their mission. There's also significant backlog amongst permitting. Permitting comes with a public process, and sometimes that can be particularly challenging for state and locals. And then last but not least, when the Fire Nation attacked, dealing with things like wildfire season, climate change, urban heat island effect, all of these things impact how air agencies are able to ensure that their attainment area or their state is able to reach or meet or exceed the national ambient air quality standards. And then last but not least, environmental justice. Air is a medium through which it's a great equalizer. Even within the District of Columbia, we have great variation within local and hyperlocal air pollution. And so over the last 50 years, we've seen dramatic decreases in overall air pollution, but still 50 years later, there are some areas of the country that are still experiencing the most impaired air quality. And unfortunately, they'll still fall on the backs of Black and Brown communities, low-income communities, and rural communities. And so all those persistent, these inequities are neither natural or inevitable. And so that is the next frontier for air agencies to use this lens of environmental justice to ensure that the programs and that the air quality programs that we're producing don't exacerbate those harms, but seek to reduce those burdens. That's all I have. This is a sparkler. These are the only fireworks that are legal. Okay. July 4th is traditionally, and since 2019, the worst air quality measurements that we get in the District of Columbia, not necessarily due to the big fireworks, but broad, widespread, sustained use of fireworks. And so this is just a graph here of the last couple of years, or up to 2018 to 2020, showing the spikes of particulate matter in and around the 4th of July. So if you see an air quality professional, hug them. This is a very difficult time for them right now.
Thank you, Kelly. That was amazing. Fantastic presentation and really good insights for us into what it's like, right? What it's like when you're actually working with this statute on a day-to-day basis, implementing it on the ground and dealing with local air quality issues. And you're getting lots of amazing shout outs for the Avatar Last Airbender. So now that we have the sort of overarching view, we've got the state and local perspective. I'm going to turn it over to David, who's going to talk a little bit about one specific area, climate change. David?
Thank you very much. I'll just start by saying I got my start after leaving ELI at Natural Resources Defense Council in 1978, shortly after the 77 amendments were enacted. So I worked on a variety of things over the years, from initially the review of the ozone max air quality standard and vehicle emissions, the hazardous air pollutant program, the 10-year struggle to get the 1990 amendments. We started in 1980. We got the 1990 amendments, which included the expansion of the air toxics program and the strata ozone program, the acid rain program, and so forth. Acid rain is about the only thing in the act, and Title V permits where I really haven't spent any time. But I want to focus on the Clean Air Act and climate change. I worked on and saw the growth of the Clean Air Act into its first international global issue of stratospheric ozone through the eighties. Oddly enough, during the Reagan administration, and it was a time of great productivity for that. Climate change has been slower. So let me start with a question, and those in the chat can quickly answer this question. I don't know what to do with you folks, so you can shout out your answers if you. I'll give you a second. Who do you think it was? First president to ask Congress for climate legislation.
The chat says Nixon. Carter.
So Lyndon Johnson, 1965, sent a message to Congress asking for new air and water legislation. It took 5 years to get it. But that message asked for authority to curb carbon dioxide because of its effect on the climate. When did Congress pass climate legislation? I maybe sort of gave that away. I'll just skip the quiz part. 1970 Clean Air Act. It included the definition that Daniel mentioned, which is an air pollutant is basically any chemical substance emitted by industrial or mobile sources into the air. And then if it endangers public health or welfare, it becomes regulated. So there's some things that are air pollutants that aren't regulated because there haven't been endangerment determinations. And then there are the ones that got the fair treatment. So when did Congress strengthen it? And the quick answer is in the Inflation Reduction Act. I'll come back to some of this as we go. Now, the climate and the Clean Air Act has gone to the Supreme Court 4 times. And while some of those decisions are problematic in how EPA can regulate, they all affirm that EPA has the authority over greenhouse gases. The first one, Massachusetts versus EPA. It's kind of amazing that it took till 2007, after the 1970 Act created the authority. But a little backstory here, late in the Clinton administration, which I was part of, I was at EPA for 7 years, only at CEQ for 1. I wrote a memo for an interagency process that said we have the authority to declare that greenhouse gases are air pollutants and endanger, and if the agency decided they endanger, then we would have to regulate them. Someone leaked this memo to trade press, and Carol Browner, then the administrator, came before Tom DeLay, then a senior Republican appropriator, and DeLay said, and this is a quote, it includes the gesture, "I demand a legal opinion." And so Carol provided the legal opinion, which backed up my memo, and it got litigated in the Bush administration, which tried to reverse it. The Supreme Court decided, as a matter of Chevron Step 1, unambiguous statutory language, that the greenhouse gases are air pollutants under the Clean Air Act, and if the administration made an endangerment finding, had to be regulated. And that case was about motor vehicle emissions. There was another case brought in by a number of states and land trusts that we helped represent, trying a different route, which was a lawsuit based on much older doctrine of federal common law authority over interstate pollution. And we ended up losing that case. The Supreme Court said that the federal common law was displaced by the Clean Air Act, and EPA had the authority to regulate power plant carbon dioxide. It was a 8-0 opinion, that set us on a path towards getting power plant regulations. There was another decision in 2014, which again affirmed that EPA had the authority to regulate, but constrained the use of one of the permit programs. Basically a mismatch that you mentioned the 100-ton definition of a stationary source. That number was picked by Congress because it worked for pollutants like sulfur dioxide and volatile organic chemicals, oxides of nitrogen. It was a good way to distinguish between big and small sources. Then you got to carbon dioxide, and it turns out carbon dioxide is emitted from these same kinds of sources in 100 or 1,000 times the volume. So the 100-ton limit would have picked up barbecues, and EPA came up with a way of avoiding that, and the Supreme Court said much simpler way to avoid that, which is just to say it doesn't cover, the permit program doesn't cover sources like that. But again, affirming the authority. In West Virginia versus EPA, the decision that overturned EPA's Clean Power Plan, it holds that EPA created something called the Major Questions Doctrine, which is probably a 202 or a 303 ELI course. But it affirmed again that EPA had the authority to set traditional technology-based standards for power plants and other stationary sources of greenhouse gases. That's what EPA is doing now for the oil and gas methane rule and the power plant rule, both which came out this spring. I'll talk about those a bit more in a minute. And then there's one lower court decision that really matters. It's turned back an attack on the endangerment finding. EPA determined in the beginning of the Obama administration, 2009, that greenhouse gases endangered our health and our well-being. And the court upheld that finding. And that's the finding that drives the requirement to address carbon dioxide and other greenhouse gases from a variety of different kinds of sources. There are three marquee climate regulations that the Biden administration has produced in the last several months. And they're all three under legal challenge, but in my view, they all stand on firm ground. And one is Texas versus EPA. Texas is leading. All these are multi-red state coalitions challenging these rules. They're all also being challenged by a variety of industries. The oil and gas rule is intended to stop the leakage of methane from the wells through the processing, through the distribution of natural gas. Natural gas is mainly methane, and methane is a very powerful greenhouse gas, 80+ times as powerful as CO2, excuse me, on a 20-year basis. And these rules are a collection of technology-based requirements, leak limits, requirements to use certain kinds of leak-free equipment in lieu of leaky equipment, and so on. And they're being challenged, but I'm quite confident that this will be upheld. Car and truck greenhouse gas rules being challenged as well. EPA's regulated pollution from motor vehicles, as Dan mentioned, really since before the 1970 Clean Air Act, started in '65. Each time setting performance standards, meaning emissions per allowed grams per mile of emissions allowed from new vehicles. The greenhouse gas rules are in the same format. They regulate the same industries in the same way. And we think, and EPA has been doing that really since 2010. So there's a very strong basis for doing that. Power plant carbon dioxide rules came out in May. West Virginia has challenged them. It's always West Virginia. These rules are written with very close attention to the Supreme Court's guidance that while the Clean Power Plant's market-based approach was not allowed, it was considered too novel. And then the idea of purposefully shifting generation from one type of plant to another was considered beyond EPA's authority. The court made clear that EPA has the authority to set traditional technology-based standards. And even if those have the knock-on effect of making some plants more expensive to operate and therefore they get used less, and generation does shift from some plants to others, Chief Justice Roberts said there's an obvious difference between them, which is okay, and the deliberate generation shifting that they disallowed in that case. So again, we think that case provides a strong backing for the approach EPA's used in the recent rules. And NRDC and various other environmental and health groups have intervened in these different cases to support EPA. Let's see. I was going to point out that the first and third, the oil and gas and the power plant rules, are among those that where the states and some industries have rushed into court ahead of normal merits briefing and seeking stays. And a stay is like an injunction. If you were in a lower court, in a district court, you would be asking for a preliminary injunction. When you go to the Court of Appeals, which is where these cases go, as Dan described, the same thing is called a stay of the implementation of the rule. And the same test applies. The person seeking a stay has to show that they are, quote, likely to win on the merits, that they would be irreparably harmed in the time it took to win the case the normal way, and that others are not going to be equally harmed, and they have to satisfy a test of where does the public interest lie, a four-part test. We think these stay requests are quite weak. The obvious goal is to go up to the Supreme Court on the shadow docket or the emergency docket and see if they can't get the Supremes to block it. There's one case pending of this same kind, the cross-state rule that Dan mentioned, and we can talk about that more in Q&A if we want. For any day now, we're going to find out if the Supreme Court stays that rule or rejects the plea for a stay. So I've already been more or less making this point in terms of the key arguments that what EPA is doing in these two areas, mobile sources and stationary sources, are traditional standards, traditional in form, traditional in every aspect. And so they don't raise the novelty and the idea of EPA pushing its authority into areas where no man has gone before. So we think those don't pose major questions. The vehicle rules, the statute authorizes EPA to consider not just add-on controls, but complete systems. And an electric vehicle is a complete system that is very effective at avoiding tailpipe, well, it has no tailpipe, avoiding emissions. Under Section 111, I mentioned the authority to set technology-based standards. The words the court uses, standards that make stationary sources operate more cleanly. So we think these things are on firm ground. The stay motions are likely to be decided by the DC Circuit Court of Appeals sometime this summer. Challenges are likely to go up to the Supreme Court on the shadow docket. This would probably come to the court in the early fall in terms of having those motions briefed. And the merits briefing will likely go on this fall with arguments next spring in all these cases. So I'll stop there. the Clean Air Act is the main tool that we have in existing law for addressing climate change. And I meant to mention one more thing. In the amendments adopted in 2022, in the Inflation Reduction Act, there are amendments to the Clean Air Act itself. And those specify that greenhouse gases are air pollutants. So it takes the Massachusetts question and like permanently puts it to rest. And there's funding provided with instructions for EPA to regulate power plants and other sources, again, taking into account very large tax credits and other incentives that Congress enacted in order to reduce the cost to, let's say, power companies and their customers. So that makes these technology-based standards much cheaper and makes the case that that EPA is being taking cost into account reasonably, very much more convincing. So the IRA is actually it's not a wholesale Clean Air Act amendment, but it's a big deal, and we'll see what happens.
Thank you, David, Kelly, and Dan, for those enlightening presentations. We have plenty of time for Q&A now. I've got a few questions that have come through the chat, but I first want to just open it up to the room. This is your chance. You have the experts right here. So if you have any questions that you had coming into today's session or that came to you during, now's your chance to ask. I think Madison has a mic that she'll pass around. So yeah, anyone have any questions? One up front.
Thank you. The Clean Air Act has been amended many times. Should it be amended again? And if so, what should be changed or added? And Kelly and Daniel, if you have a problem with the way that question is phrased, I can rephrase.
I don't think I can speak to that.
I was wondering then if you could maybe describe, because I'm sure you're a part of conversations in rooms where these things are discussed, maybe you could describe them sort of from a, not your own perspective without giving an opinion, but what things have been discussed and why might they have been discussed?
Well, I mean, maybe I'll hazard a little bit something. I mean, probably safer to give you my own opinion rather than speak more generally. I mean, I think you know what Kelly was saying about resources is actually a really important one. There is a lot of turnover. There's a generational change here, and so just having expertise in you know, in all these areas, like running the monitors. I was talking a couple of years ago to one of our monitoring experts and talking about how it's hard finding people that are interested in running an air quality monitor. It's really complex. It's very technical. It takes a lot of expertise and training, and so there are just, you know, resource issues like that, which I mean, hopefully the IRA sort of helps with to some extent, but just having adequate resources at the state level and the federal level is a big kind of continuing part of I think the ongoing work of the Clean Air Act, and something the agency always is, you know, we always need to, we have to be funded, right? Congress has to fund us, has to fund lawyers to do the work, and has to fund engineers to do the work. And so just having the capacity, this is highly, as I was listening to Kelly's presentation, I was, you know, reminded, as I don't really need to be, but just how complicated it really is to translate these requirements into you know, the engineering analysis and the modeling analysis that goes into every single, you know, facility permit or state plan requirement. It's a huge effort, and so continuing to have resources for that is really important. In terms of other ways to amend the Clean Air Act, again, I will probably have you pass it.
Maybe not other ways to amend, but in my former capacity as the state air pollution control officer for the district, one thing that we were discussing is the continued appropriateness of the form of the standard, the fourth high over the last 3 years. especially given that overall emission reductions are more difficult to achieve over broad geographical regions, and that a more targeted approach could be a more appropriate as, you know, for example, if the United States was obese with emissions and needed broad sweeping programs at one point, now there's problem areas to target and a more targeted approach. And so also the Ozone Transport Commission had petitioned EPA for some changes, for example, to change the size of the ozone transport region. There's been efforts to expand that based on some downwind effects from states that are not within the ozone transport region, and then thus not subject to the enhanced controls and emissions reductions programs that the OTC member states are required to participate in.
That was actually my case. We can talk about it later.
We can talk about it later. And so, and then just awaiting a solution for cross-state air pollution. Many downwind states struggle with attainment and have done the linkages to upwind states, but getting where's that one?
The Good Neighbor Plan?
Mhm.
Yeah, so that's the rule that's pending in the Supreme Court right now on a stay application, and we're in merits briefing in the DC circuit. We just filed our merits brief yesterday, actually, so if you want to read an awesome brief, tour de force, it was just filed yesterday in the DC circuit, defending the Good Neighbor Plan. So that addresses the interstate pollution for the 2015 ozone max.
Yeah. And so what Dan was saying about the Clean Air Act having a lot of limits and deadlines and times when things have to happen for state and local authorities. Let's say you have an attainment deadline coming, but you need a rule that influences like emissions in another state in order to attain. It causes a ripple effect, waiting for the rule, waiting for the actual on the ground actualizations of the emissions reductions, to monitor the reductions, to demonstrate attainment. And so I think that's,
I could offer a couple of thoughts.
never saw a clean air rule that didn't get litigated.
Yes. Well, actually, there's a few actually. The original conception of the air pollution problem was hyper-local. But we learned over 50 years that what we thought of as local smog problems have an upwind, air transport, or regional. Things we thought of as regional or national or international. And at the same time, we have this problem with the community level disparities in pollution. So I'm not sure we can get this, but it would be really good to have a much denser network of monitors. Some areas, I don't know about this area, have very, very, like 1 or 2 monitors that characterize an enormous geography. And you miss the fact that some areas of that city are more polluted than others. At the same time, the most effective programs, at least by some measures, would be the ones that were implemented directly by the federal government. The motor vehicle standards between California and the federal standards have been an enormous success. Still more to do, but enormous success. The acid rain program, administered nationally, no state involvement, and that went extremely smoothly. That's where a number of rules went through with no litigation. Same to the stratospheric ozone program, administered nationally and in conjunction with the Montreal Protocol International Treaty, and it went very smoothly. Now, until we get the Clean Air Act modernized, if we want to deal with greenhouse gases on the stationary source side, we have to use section 111D, which involves the state implementation of federal standards in the same model as the basic health standards. It's awkward, but it can work. And we're going to use the tools we have. The original Clean Air Act, 1970, as you pointed out, was almost unanimous, bipartisan. It's gotten highly partisan. And you can ask me why, if you want to know more about that. But it makes it very difficult to enact amendments to the Clean Air Act. We did get the AIM Act, which Dan mentioned, as an amendment to deal with stratospheric, with substitutes for stratospheric ozone depleters that happen also to be climate changing. And we got that on a bipartisan basis. And we got the Inflation Reduction Act on a totally partisan basis. But those are the two recent enactments, and we have to figure out a way to get this back to some measure of bipartisanship.
I want to pick up on one thing you said, David, and that's about monitoring. And there was a question in the chat, and I was wondering, Kelly, if you could speak to this maybe. How are the non-attainment areas identified? I mean, what is the monitoring look like? I mean, is that done at the state and local level, or can you say anything about the monitoring aspect for us?
It is done at the state and local level. Federal reference grade monitoring is, it's like the thermostat in your house. It's just designed to give you a general sense of the room. And so there's a science to deciding where and how those monitors are placed, and it's standardized across the country. The network is relatively sparse compared to what we know are the variations in air quality across, even like across the District of Columbia. But they're designed to normalize and kind of give a general sense of the ambient air quality of an entire region. There is a lot of like hyper local monitoring progress, new technologies and capabilities. There's a recently launched satellite called Tempo that gives hourly tropospheric NO2 column measurements. And like, so we have new data sets, but the ground-based monitoring network is really like that thermostat in your house. So it's not going to tell you if the kitchen is on fire, but it will tell you if everyone in your house is closely packed together and has a fever right next to it. That might blip on a monitor. So usually sometimes trying to use those ground-based monitors to kind of assess like hyper local regions, it's just not an appropriate use. And so like trying to compare your monitoring system, the ground-based monitoring data to, let's say, like low-cost sensors or hyper-local monitoring sensors, it's just a different scale. And so there's just lots of different ways that you can address that. But for attainment, it's that it's the gold standard. Those monitoring stations are certified. They are aggressively quality assured. And I think it takes 5 years before a monitoring station, you have to petition EPA to make it part of the network. And so there's a lot of QC, and I think the data capture rate is required to be 70%, but most states exceed that, except for during the pandemic. The District of Columbia did maintain monitoring capability throughout, but what that meant is, monitoring staff were in the monitoring stations, changing filters, monitoring management equipment, sending samples to the labs, almost every 3 days. I think we have 5 monitoring stations in DC. We just added one. It's not in the network yet, but a newer station added as part of ARP money in southeast part of DC. A quadrant of DC where we had no monitoring before.
One just really quick add-on to that is, and there are regulatory monitors, there are non-regulatory monitors, there are citizen science, people using their phones, et cetera. One sort of deep cut from the Clean Air Act I'll just mention is the credible evidence rule, which is a provision that establishes that when people are trying to establish violations of the Clean Air Act, any credible evidence may be admissible. So there is sort of a long-standing role for sort of a citizen science or data gathering that could play a role there. That sometimes, I don't know if it's come up recently, but sort of a long-standing principle that's been a part of Clean Air Act implementation for a while.
And I talked a lot about like the monitoring network and ambient air quality monitoring, but especially at Title V, like major source facilities, there's also fence line monitoring and point source monitoring and continuous emissions monitoring systems that are used to validate compliance with like permitting requirements for individual pieces of equipment or like area or major sources.
If the Chevron doctrine is indeed overturned in the coming months, what will the immediate implications be for the Clean Air Act?
David?
Well, as some of you may know, I argued the Chevron case 30 years ago, and I lost because we were arguing then that the definition of a stationary source was absolutely unambiguous. The court disagreed. So a lot depends on what the court does now. The right-wing advocates are looking for a complete reversal. It actually helps to say what was the key message of Chevron itself. Because Justice Stevens wrote an opinion in which he said that lower court judges, in this case it was on the DC Circuit, had been guilty of inserting their own policy preferences in over those of the administrative agencies. And they should stop that. Yeah, you have a role when the law is clear, you've got to tell the agency that they can't do that. And if the agency's policy views are completely off the wall, you can tell them that too. But when Congress writes these laws, especially these laws are complicated, they're trying to anticipate, they're trying to provide authority for an agency to help a Congress that doesn't have the bandwidth to deal with these questions, maybe for once every 10 years. Case of the Clean Air Act, it's been 34 years, I think, since the last wholesale amendments. The message was these laws are posing policy questions for the agencies to resolve with both their technical knowledge, but also their political accountability. They're accountable to the president. The president's elected by the whole nation. The Congress is elected. The judges are not. And judges need to be humble and keep their own policy preferences in the background. The maximum request coming from the other side here is tell judges that they are now free to roam about the country and insert their policy views over those of the agencies willy-nilly. I think that would be a very bad outcome, and it would not just overturn Chevron, but really 100 years of judicial review principles that went before that. And I don't think that, I would be really surprised if that's what comes out. A more modest outcome is one that tells the judges to spend a bit more time struggling with whether there is a clear meaning before you reach the conclusion that it's ambiguous, and then before you defer. But still, it would keep the same framework. And there's also a sort of backup request from the current petitioners saying, well, it's one thing when the law is ambiguous, but what if it's absolutely silent on a given subject? Does the agency have any authority when a statute is silent? And of course, one man's silence is another person's whispering. But we can have a lot of disputes about what is absolute silence. But it's not a terrible idea, a terrible conclusion if the court says, if the Congress has not addressed something at all, then it hasn't given the agency the authority to address So we'll see what comes out. Just with one more comment. I think the Clean Power Plan from 2015 is the last major rule that I know of where the agency relied on the Chevron deference principle in the preambular explanation of how they've interpreted the law and why they're doing what they're doing. And the agency doesn't do that anymore. The agency says, here's what we think the statute means. Here's what we think its best reading is, which is one of the alternate tests that some of the justices have proposed. And, here's why we think we're right in interpreting it this way. So I don't think there'll be many, if any, EPA rules that fall simply because the agency relied on Chevron. If Chevron is somehow overturned. But it depends on what they do. It depends on how much freedom this court is going to give itself and lower court judges to substitute their own policy views for those of Congress and the agencies. And I feel that is a very bad trend as it's been happening. Go read the bump stock decision from last Friday. And it's the opposite of judicial humility and restraint. That's what happens.
I just want to add, I'd be remiss if I didn't point out, we at ELI, we've been thinking a lot about this over the past several months. We published a research report just last month called The Supreme Court, Environmental Regulation and the Regulatory Environment. Chevron really is sort of like a central character in here, and we really do trace sort of the last 50 years of the arc of federal environmental law and its interaction with the Supreme Court. And if you're interested in reading more, I'd really encourage you to check out our report. It's written in plain English, so hopefully it's accessible.
Last summer, ELI published an article that I wrote called Clean Air Act. What do we call it?
It's like West Virginia Clean Air Act and the future
West
of
Virginia
climate.
yeah. And it traces the development of the major question doctrine out of Chevron. And I critique some of this stuff too. So if you're interested,
Check it out.
check it out.
Any other questions in the room?
I have a habit of asking really niche questions about agriculture. The Clean Air Act does a pretty good job with major stationary sources. It does a pretty good job with automobiles, but with like the increasing industrialization of agriculture and specifically animal agriculture, that seems to sort of be falling through the cracks of a lot of the major environmental statutes. And I feel like the Clean Air Act is kind of no exception. How do we address that? How do we kind of begin to capture and monitor and regulate emissions from agriculture?
CAPOs?
Yeah.
I just know the word. It's the concentrated
Yeah,
animal feeding
CAPOs, yeah.
operation.
CAPOs.
We don't have those in the District of Columbia.
Yes, you do. It's Union Market.
Every time I say that, someone says, oh, wait a minute, they'll find it, but I'm not familiar, but there are.
Historically, I'm not gonna offer an opinion, but I mean, historically, I think there was a petition to the agency a few years ago to list CAPOs and regulate them under 111. So there's, there's some history there, there's some case law that might, you could research into. I imagine there's, a fair amount of academic literature that's been written in law review articles about whether these kinds of facilities fall within the definitions of sources under the act. I mean, there's certainly been, I think, a lot of thinking about it. I honestly don't know where the agency is at exactly right now, so I don't want to speak beyond that.
The basic problem is political. The Senate is made up of, it's disproportionately rural and agriculture sensitive. And Congress passed I'm trying to remember exactly when it was, a provision requiring EPA to establish the greenhouse gas emissions reporting system. And it applied to, all kinds of sources, including it would have applied to CAPOs. And the agriculture lobby succeeded in getting the Senate to sponsor an amendment every year to the funding legislation that exempts CAPOs from the greenhouse gas emissions reporting. So it's a political problem. It's not a technical problem. You could figure out methods of controlling methane emissions from waste ponds and even from, there's even some interesting ways of masking cows so that they exhale into a mask and then the methane is captured. Comes from the front end, by the way. Agriculture's pollution is poorly regulated.
I'll add that at the state and local level, not as an air pollutant, but when you have air agencies or other jurisdictions that regulate odor, that's another way that sometimes state and local agencies are addressing people, especially when there are odor impacts to neighboring properties.
I attended my daughter's college Frisbee championship downwind of the Capo in the Central Valley of California. It was horrible.
I visited a rendering plant in Denver. Not smelled terrible.
Frisbees twice in one panel. Amazing.
Shout out to Frisbee right now.
Yeah.
Isn't it amazing?
Well, it was Justice Scalia who said that the Clean Air Act doesn't regulate Frisbees or flatulence.
I have regulated styrofoam balls.
Yeah.
But we do have one up here too.
Yeah. That's your expertise.
First of all, thank you all for coming here today. This is maybe a little of an LRS heavy question, but I was wondering about the rationale behind the design of the Clean Air Act and that like grandfather clock system that you talked about. Like, what are the pros and cons of having all these deadlines? Do you think it spurs more action, or do you think dealing with all that litigation can kind of slow things down?
Well, I think it definitely keeps the agency's feet to the fire, I don't. There's commentary around that. I think, there's both sides to it. Some people can say, well, when the agency misses so many deadlines, then the people who bring those suits to force the agency to act can, to some extent, drive the agenda. I don't necessarily agree with that, because I think the deadlines in the act reflect Congress's priorities. So if Congress said something needed to be done by a certain date and it's not done, the provisions for enforcing those deadlines are part of the congressional structure that the agency, has to implement, because we are a creature of the statute. And so in that sense, it does more or less keep us aligned with what Congress identified as priorities. Overall, I think Congress intentionally, wanted an accountability mechanism in the act.
Well, one of the historical problems with regulatory agencies is capture. You're trying to regulate an industry, you get too close to the industry, you hear only from the industry, and after a while, the teeth gets softened or pulled, and the agency becomes a defender of the industry rather than its regulator. One of the great innovations of the Clean Air Act and of the other environmental laws passed at that time was to include expressly the authority for citizens groups to bring challenges under 307 to the final actions the agency takes. So it's not just industry, but it's NRDC that can challenge, and the same with the deadline suits, as Dan just explained. A law like the Clean Air Act was intended to, to balance the liberty interests, so to speak, of not just the polluters, but of the people who are breathing the pollution. And in order for the people or the groups that represent them to have any leverage, so to speak, Congress provided that we had the access to the courts. And that means that when we file comments on a proposed rule and we identify some flaw, let's say that in some way in which it's not legal or some way in which it's arbitrary and capricious, the agency has to take our side's comments with the same seriousness that it takes those of the industries. Because each side has access to the courts. And it's just been critical in keeping EPA from being captured, that these two provisions exist and these rights of participation exist. Now they're being extended, so to speak. They've always been technically available, but efforts being made to make these protections more available to communities that are disproportionately affected. And it's actually a pretty strong commitment of this administration and of Administrator Regan. And I think that's all for the good.
And I'll add that state and local agencies also comment extensively on rules as they're in progress. Because it's important to tell EPA, how the rule implementation will play out in particular states, and kind of share, especially impacts related to like environmental justice or conflicts with existing rules or programs that are already in place in some jurisdictions.
Hi. Obviously, the Clean Air Act is really technical and complicated. I was wondering how you guys got into this field and whether you guys had a technical background or a science background, and if you think a technical background is necessary for the jobs that you guys do.
I can start with that. I think it's a really, really good question. I actually was a philosophy major at a liberal arts college, so really did not have any or much technical background before going to law school and wanting to do environmental law, partly because I didn't want to be a scientist or an engineer, but I wanted to work in the environmental field. So in my experience, I mean, I don't think it's technically necessary, but I think it is important to have an aptitude for it, even if you don't have a degree in it. Like I have to, on a daily basis, as an attorney in OGC, I'm regularly reviewing statistics, spreadsheets, calculations, data that like I want to understand it. I at least want to have a working knowledge of it to be able to do my job most effectively. I don't think it's necessarily absolutely required, but I do think particularly with the Clean Air Act, it's highly technical. There's a lot of math, there's a lot of statistics, there's a lot of modeling and data. And so like if you enjoy that kind of stuff, even if you don't have a statistics background, you will enjoy the work. And if you enjoy the work, I think you'll do good at it. So that's sort of my answer. I don't think it's needed. There are a number of people. I certainly on your resume, I think if you both have the background for or the qualifications for being a Clean Air Act or an environmental attorney, as well as having some more technical training, STEM education, whatever, I think that will probably be a help for a lot of hiring situations like that. But again, I don't think it's strictly necessary.
We do. I came out of this. I'm a fallen away city planner. City planning was interesting to me until I started the courses like that in Berkeley, and it turned out to be really boring. And then this is in 1974. I had a course in what was brand new Clean Air Act, taught by a landscape architect and a law professor, and that got me interested in going to law school. But I don't have a technical background. We do work with at NRDC. It was formed by half a dozen lawyers, but they very quickly realized that you need scientists, engineers, people with quantitative and analytical skills, economic skills. And so we work in teams. And what's so fun about this is that I get a kind of I might be able to pass a master's exam in atmospheric chemistry, but probably not at this point. But you do get to learn the basics and the concepts, and then you have people behind you or beside you who have the real skills. So you can come at this through all these different angles, and there's room at EPA or in environmental organizations, frankly in businesses too, for people with multiple backgrounds.
Yeah, I think one of the value added actually as the lawyer, the same with EPA, we have multidisciplinary work groups to develop rules. And so it's also a bit of a luxury almost within the agency that we have modelers and we have engineers and we have the tech. So we're not, I get to rely on them to a certain extent. I think if you're in an advocacy organization or a small organization, that some of that work does tend to can fall more on the lawyer. But I'm lucky enough to work with, teams of people who are our analysts who really do the number crunching. But then the role of the lawyer and the role of other, people who are working more in the policy realm is to sort of shape that. You got to take that data and you have to be able to translate that into a rule, into a rationale for that rule that's defensible and that's understandable by the courts. And that's the work of lawyers to being able to be the person that says, I'm going to ask you some really dumb questions is actually an important power, because it allows you to ask the question that maybe nobody else wants to ask. And she can sometimes produce some really insightful new thinking.
I'm not a lawyer. I'm an engineer by training. I started out with air quality by accident, but I was one of the environmental contractors at NASA Goddard Space Flight Center. So I started out managing a Title V facility. # do not recommend. But I stayed in air quality for most of my career, even when I was trying not to. But it is highly technical. If you go back to my slide about making friends, we have lots of multidisciplinary teams. My program attorney is always very close at hand because you see the modeling, you know what needs to be done, and working with the attorneys to figure out how to do it without getting sued.
Or defending when you do get sued.
We'll take a question from the chat here. It's about data and where you can find good data. So what is the best place to find up-to-date data on air standards? And sort of related, is there a national rating or scoring system that measures the annual or overall air quality in a state?
So each state it's a lot of work, but you'll get the most up-to-date data directly from a state. There's a delay in, I think states have 6 to 9 months to certify their data before they transmit it to EPA. There's some data streams that go directly to EPA, like continuously, for example, for the air now system. What was that second part of the question?
Where's the best place to find the data, and is there a national or rating scoring system?
Well, there's a national emissions inventory, if that
It sounds
is what
responsible.
we're looking for. So there's a national emissions inventory. It only comes out every 3 years, and that's on a delay. So that's the most up-to-date, most robust, most complete, most quality controlled data set. And it's the one that's used as a basis for all sorts of rulemakings. So I would say that, but also state and local agencies do have more data than what they are required to report to EPA. And that they use. Oh, I was going to say that they use to do rulemaking in their own jurisdictions.
I was going to mention the American Lung Association's State of the Air report comes out each year, sometime in the spring.
A lot of so EPA, there are a lot of databases. It can be hard to navigate them. One that's sort of like a not one-stop shop for criteria air pollution data is the Green Book, the epa.gov/green-book / let's get this confused, but I think if you Google Green Book, you could find, so you can get a lot of data, a lot of monitoring data about air quality through that. The emissions inventory, yes. If you want power plant data, we have really excellent power plant data because they're required to monitor their emissions under special regulatory requirements called Part 75. And so if you go to the
E-grid.
what's that?
E-grid.
E-grid? Oh, I was gonna say, well, Camp D or something
Camp D.
like Camp, that's
The Camdy is.
Camdy's the
Your market.
office, and then their website's like Camp D or something, but anyway, I don't know, if you Google EPA power plant data or something.
There's also the greenhouse gas database, which is down to the, it collects all the information reported by the large stationary sources and plots it on maps, so you can see what's happening in any state or nation as a whole or particular industry.
And most states do trends reports.
And then EJ Screen, if you want to specifically look at EJ the EJ Screen is a sort of GIS mapping tool that's pretty cool, and I think they've improved it over the years. I think the EPA is often careful to caution that that's sort of like just a screening tool. They're not making any specific regulatory conclusions out of that information, but it is a way to start to sort of like identify proximity, demographic groups, and things like that associated with particular sources of air pollution. So the EJ Screen tool, I think, is also something that's publicly available.
It's a perfect segue into someone in the chat is also asking sort of about the modification of the PM 2.5 network design criteria to now include an environmental justice factor. Does that sound familiar to you at all?
I feel like we're now in Clean Air Act 303.
Yeah.
This is 303. Okay, sounds good.
I don't know anything specific about that.
Okay.
I think I read something about that. Yes, I mean, interestingly, just back to 101, the PM NACS was just revised earlier this year. So that was some big news out of the agency. It was tightened to from, I think it was at 12 the PM annual standard was tightened from 12 micrograms per cubic meter down to 9 micrograms per cubic meter. Whenever that NACS is revised, it triggers all of these new planning requirements that states have. And I think this person might be referring to something that was changed in conjunction with the tightening of the PM standard, but I don't know anything specific about it.
I remember when they were reviewing the PM standard, that part of the risk assessment showed that there were great disparities amongst different populations in in risk factors associated with particulate matter exposure. Even at the proposed reduced standard, I think it was 9 micrograms per liter. And I want to say the World Health Organization released a PM standard. Their standard is what, 6 micrograms? I'll look it up.
Let's reel it back to 101 here for a second. A question about sort of market-based approaches. And I was wondering if maybe you could speak a little bit about whether or not the Clean Air Act has any market-based approaches, if there's any sort of cap and trade. I'm thinking of the acid rain program maybe. And then there's also room to maybe discuss, David, if there's an opportunity to address greenhouse gases through the Clean Air Act and a cap and trade framework through that law. Yeah, anything about market-based approaches in the law?
I'll take the first part and then you can take the second part. In the 1990 Clean Air Act amendments, again, I think Congress largely embraced the idea that market-based programs could work to reduce air pollution. Not only did they do that through the acid rain program, but through numerous other revisions of the act that are less familiar, but which authorize the states or EPA to take market-based approaches. So for example, probably the place that is seen most is in these interstate transport rules, which if you go back to the NOx SIP call in 1998, CARE, which is a Bush administration rule in 2005, CASPER, which is an Obama rule in 2011, and then you've got CASPER update. This is my program, so this is my home territory. These are all of these programs have been implemented through market-based emissions trading programs that I think we could say overall have been very successful in reducing interstate pollution, particularly NOx and SO2. So, and the authority for those trading programs comes out of some revisions to the act that were made in the 90 amendments that were in section 110, as well as in the definition of a federal implementation plan 302, which specifically included some language along the lines of, and I'll probably paraphrase it, but like effectively, the kinds of control measures that states or the agency could implement in these SIPs and FIPs are market-based, marketable permits, I think they referred to them as. So there was sort of a general authorization to use market mechanisms in the Clean Air Act. And the other place I think also market-based programs and also emissions averaging actually has a pretty long pedigree in the Act, even earlier than 90 amendments. For example, the mobile source standards are typically implemented on fleet-wide averaging. So we've been doing a sort of averaging or trading approach with emissions with mobile sources going back all the way to the earliest standards. So in general, the Act to this day, I think, continues to embrace the idea that market-based approaches can be implemented appropriately. But the one extra little tag I put on it in the recent Good Neighbor plan that we are now defending, one of the things we did with those trading programs was try to put some bumpers on the amount of trading that can happen, because unrestricted trading creates other kinds of problems. You can have EJ, EJ groups have often been concerned about that, creating pollution hotspots. So there are countervailing considerations in the design of trading programs. The agency has generally, I think, been fairly aware of those, and in the most recent rule that I've worked on has actually made some changes to try to ensure that trading doesn't undermine the ultimate environmental objective of the program.
But you said that one of the reasons why NRDC has supported these market-based approaches in many instances with concern about the guardrails is that if you make a program more flexible and thus cheaper to implement, you can make the target stronger. So the acid rain agreement in 1990 was, I think, a 9 million ton cap, if I remember correctly, on total sulfur dioxide emissions nationwide, implemented through a cap and trade program. We never would have gotten the industry to go along with that, even as reluctantly as they did in 1990, if it had been less flexible and didn't allow them to sort of optimize which plants they would control, over control, and which ones they would use credits to bring into compliance, so on. Same thing with the stratospheric ozone program. The phase out of CFCs and the phase down of HFCs is conducted through a cap and trade program. That memo that I mentioned that I wrote in 1998 said, yeah, the EPA has the authority to curb greenhouse gas emissions, but the authority we had, that was at EPA at the time, quote, did not easily lend itself, unquote, this is 111D, to a cap and trade program. We didn't rule it out, and the agency tried a modified version of that in the Clean Power Plan, and that led to the Supreme Court decision, not citing my memo, basically saying, yeah, you can do that where Congress has told you you can do it, but you can't do it under Section 111D because it doesn't have the. They interpreted it as Congress not providing that authority there. So it would be hard to construct a cap and trade program for greenhouse gases under the Clean Air Act with those constraints, which is why EPA is working in the traditional pathways on mobile sources and in power plants and other industries, and why I think those are legally sound.
There is a regional greenhouse gas initiative, but that is a state local effort. It's 7 states in the Northeast. It is being litigated. I think Pennsylvania it's been deemed unconstitutional in Pennsylvania, and I think Virginia is attempting to withdraw from Reggie. The District of Columbia is not participant ready. DC doesn't have any energy generating units, so Maryland and Virginia get the credits for energy used in DC for Reggie. But that has been around since like 2005 or 2009. So there are examples of, like, that's a greenhouse gas trading, cap and trade program, that still exists.
Yeah, so alive and well.
It's alive and well.
Alive and well. It's a great place to end it. With thanks so much to our panelists for an absolutely fantastic presentation. Thank you all for joining us. And I think they'll be sticking around for a couple minutes after if you want to meet them. So thank you so much.
Thank you all so much. Thank you to all of our speakers for being here. We so appreciate it. And thank you to our in-person and virtual audience for tuning in. We'll see you next week virtually for the Clean Water Act session, and then in 3 weeks from today for our energy session. Thank you so much and have a great day.
Thank you. That's so good.